So we are going to go ahead and get started. Good morning, everyone. My name is Elizabeth Aloni with Schneps Media. We're excited to present National Healthcare Decisions Day, Get Your Advance Directives, a very important webinar. Just to let you know who I am with Schneps Media, and we publish over 80 newspapers, magazines, websites, webinars, podcasts, and events throughout Queens, Brooklyn, the Bronx, Manhattan, Staten Island, Long Island, the East End, Westchester, Philadelphia, and even now Florida. So we are thrilled to have you here with us today. We have wonderful experts to be able to walk us through this and understand what National Healthcare Decisions Day is about, an opportunity for us to take stock and ask ourselves, do I have advance directives? Who's going to help me make healthcare decisions and help bring awareness to the importance of these very important decisions that you need to make for yourself and for your loved ones. So let me start off by introducing our award-winning panelists who are going to walk you through everything that you need to know. First, please welcome Marcus O'Toole, partner at Cona Elder Law. As a member of the estate planning department, Mr. O'Toole handles the preparation of wills, trusts, powers of attorney, healthcare proxies, and living wills. As part of the estate administration department, Mr. O'Toole is responsible for the preparation and filing of surrogates court petitions, including petitions for probate or administration, and assists clients with the day-to-day administration of estates. Welcome, Mr. O'Toole. May I call you Marcus?
Of course. Thank you for having me.
My pleasure. My pleasure. Thanks for being here. Now, please welcome senior partner at Cona Elder Law, Melissa Negrin-Wiener. And Melissa manages the government benefits department, concentrating her practice in the areas of asset protection, Medicaid eligibility planning, estate planning, special needs planning, mediation, guardianships, and veteran benefits. She supervises the preparation of Medicaid applications for nursing home care, home health care, and community benefits, resolves complex Medicaid issues, and represents families facing a reduction in Medicaid home care hours and services. Wow. And is it okay for me to call you Melissa?
Of course.
Wonderful, wonderful. Welcome, Melissa. Thank you for being here.
Thank you.
So let's get started really with the basics. So what exactly are healthcare directives or advance directives, excuse me?
So advance directives are basically documents that that you sign in advance of becoming mentally incapacitated, let's just say, or incapacitated, illness, accident. When someone becomes incapacitated, they can no longer sign these documents. So it's power of attorney, healthcare proxy, living will, and essentially you're putting on paper who you want to handle these things for you in the future if you should become incapacitated for any reason. And Marcus, I think, is going to take us through each of the three documents.
Oh, thank you. Melissa's right. They're really core documents that allow someone to make decisions for you at some future point where you couldn't make them for yourself, whether that's accident, illness, or some other reason that you couldn't handle things. And I think most people kind of understand, healthcare decisions, if I'm in a coma or a hospital or something like that. But arguably, even the power of attorney is often overlooked and often the most important thing that you have to set up ahead of time. Because for some legal and technical reasons, there's no, easy alternative to not having one. And so a power of attorney it's a legal document where you name someone as your agent to be able to make financial decisions on your behalf. And it's someone you trust to handle these things for you. And the financial decisions can vary widely, from very small things like making sure your cable bill is being paid, to dealing with insurance companies, to a pension company, to managing investments for you, to selling a house, right? Or transferring assets out of your name for Medicaid planning. So there's a very, very wide range of powers that a properly drafted power of attorney can do for you. But that's what they're used for, right? If you couldn't make these decisions for yourself, you'd want to have someone and someone's able to make those decisions for you, whatever that may be, the small things, the big things, everything in between. If you couldn't do it, you want to make sure that you have someone in place to do that, and that there's someone you trust, and that you have alternates and things like that. So the power of attorney is really where people often, forget to start, because it's a core document. It's kind of complicated to look at. You can't just download it off the internet and fill it in. It doesn't really work like that. You run into a lot of trouble doing that, actually, because they're very technical documents. And even the most basic one might not be enough. You really need the fulsome power of attorney to make sure that your agent has all of the authority. And Melissa, that often creates problems when people have the really basic ones, right? When it comes to Medicaid planning.
Absolutely. And we see that all the time. People who download the documents off the internet, or even just have a standard short form power of attorney. If you take a look at the document, you'll see a modification section where we can actually add powers and modify powers that are in the basic powers, to make sure that, especially our clients who are going on Medicaid, if they have a loved one named as their power of attorney, that they need to get bank statements or deal with IRAs or change beneficiaries. The standard language in the document itself really doesn't get you there. You need to have those modifications, and you have to be an attorney who practices in this area to know what you need to have in that part of the document.
That's a good point to say too, because not only is it important to have a professional, an attorney handle it, but it can't just be your brother-in-law who's a real estate attorney. It has to be someone who really understands it. And I think as a person who has done some of these things, you don't know what you don't know. I wouldn't know if something was missing from it if I downloaded it from the internet, or if my brother-in-law, the real estate attorney, put it together. I wouldn't know all of these things that you're saying about the Medicaid piece and all these other pieces, or the questions that you ask to be able to get me to where I need to go. Right. So, thank you for telling us that, because I think, this day and age, people think, oh, you can pull things off the internet, but it's not that easy. And these are critical decisions.
Right. A really good example of something that really someone in dedicated to the field would understand, that maybe a layman or another attorney, you look at the power of attorney and it says, oh, do you want to authorize your agent to make gifts of your assets? And most people are like, oh, why would I want them to give my assets away? But think of it this way, you have a married couple, and, they didn't have a trust, which is a whole nother webinar. And one of them, needs, they're older, they're in their 80s. One of them needs, nursing care or home care aid, tomorrow. And they own a house together. It's in their joint names. And the spouse that needs care is incapacitated. And in order to get Medicaid benefits and not have a lien on their house, you have to take the ill spouse's name off of the house, basically give it all to the well spouse, right? Take their name off the deed. Well, legally speaking, that's considered a gift, right? The ill spouse is giving away their half of the house to the other. Well, if you have the basic power of attorney, you can't do that. You have to have the proper gifting authority. So you may think, oh, I'm never going to need to make a gift, or my agent doesn't need to make a gift for me. But what if, you can name your other, the husband is sick, but he had a power of attorney before naming his wife as the agent with full powers, then she could take his name off of it so he can get the benefits he needs, and their house isn't going to have a lien on it and what have you. So that's really important, to pick out that, so there are certain things in this area that you really need to be a specialist in or have a lot of expertise to realize that that's an important part of things beyond just, the basic one you might, download off the internet. So that's really important. And all right, so as to the power of attorney, say, okay, I've decided I need a power of attorney. How do I think about an agent? Who should be my agent? Well, first off, you can have multiple agents either acting at the same time or in succession. So a very common arrangement is, okay, you have, again, I'll use the very vanilla, married couple with 3 kids, right? They can say, okay, my primary agent will be my spouse, and my alternate will be one child at a time, right? Okay, I'll appoint my son, then my daughter, then my other daughter. And that's fine. They say give you a primary agent, and then if they weren't able to take care of things for you, have alternates in place. Alternatively, you can have co-agents, right? So you could say, all right, I'm going to have my spouse first and then all three of my children as alternate agents. And then they can, act separately. So if you have three children who are agents together, they could act independently from one another, right? So you don't have to have three people signing every, check to Cablevision or what have you. That makes it easier to use. And sometimes people will, so their children don't feel slighted that they picked one off, over the other. If you wanted more checks and balances, you could make it so that they all have to act together, but that can cause, just kind of administrative headaches. But, you can pick whoever you want as your agent. It could be your best friend, it could be your cousin, it could be your nephew. You just have to be very careful with who you select. And then sometimes, and this is a conversation I know Melissa has with a lot of our clients who are getting older, is even if you have a living spouse, but if they're not well or struggling with things, perhaps having children as a primary agent or co-agent currently, not as an alternative. So Melissa, you've run into that before, right?
Yeah, actually, a great example. I met with a family recently where, both the husband and the wife were capable, but they didn't have a very good handle on what they even had. And so I suggested, don't remove your spouse as the agent, but why don't we put the kids up there with them? So they happen to have two children. So each of them now has their spouse and their two children as their primary power of attorney, acting separately, because the truth of the matter is the spouse is not going to do anything, whether they need to or not. But it was not the type of situation where I could really say, age was the factor or anything else. Sure, your spouse could be on there, but let's get your kids on there too, not as a backup. So the spouse has to resign in order for the kids to step up, but more of an equal. So it's really important for us as part of our meeting with our clients to really understand the family dynamic and kind of how all the inner workings are happening so we can make the best recommendations.
I think that's another point why it's so important to really go to an expert and discuss these things, because these are the questions that you have to answer and you have to be honest about is, what is the situation? Because I was thinking, can there be, a problem if you have siblings that are, all in charge together? And those are the kind of things that you walk through with your client to determine what's the right decision to make. And I think it's hard when you're so close to it. And it's wonderful when you have an expert who can walk you through that. And you can't minimize the importance of that.
We've certainly seen, plenty of sibling conflict when it comes to these things. And it really kind of crystallizes when the parent starts to decline. And look, most families, people are getting along and you don't have a problem. But caregiving can cause strain. It can really put a burden on the family that, one feels they're doing all the work. You have, someone from the West Coast or out of state, trying to get their 2 cents in. And, having too many cooks in the kitchen can cause their own problems. If you have 3 agents who can't stand each other, that's really not a good solution, right? And it's another reason why having a good conversation with the family about who you would want. It's not just, I don't want to pick one child over the other. Well, if they're not going to get along, really, it's not worth doing. And it's better, even if, someone feels slighted a bit, to pick the one who is most likely to be the most helpful and the most effective, if you have multiple people to pick from, unless everybody gets along excellently. I don't usually recommend having 3 agents, maybe 2, but 3 or more is just a really kind of burdensome. But it's really that caregiving can put a lot of strain on the family and kind of open up old wounds. And I know Melissa has seen a lot of that through mediation and other things where, you have, family members who are out of town or not involved, just kind of coming in, and it really creates a lot of problems sometimes.
Yes, we call them the swoopers. They swoop in and try to just kind of take over everything. And we do. We see it all the time. So again, that's why it's really important And I think something that really separates us from a lot of other law firms is to really take the time to get to know the inner workings of the family and the family dynamic. It's such an important part of the planning process. You can't just do the boilerplate kind of plan for everybody that walks in the door, because it's just every family is different.
Right. And on the other end, the local caregiver might not be doing the best job. And you might have someone who's not in town who really just is getting locked out of information. And there might be, shenanigans going on with the finances and other things that happens, right? There's
Absolutely.
right. So it's not just, swooping is a problem. And it happens a lot, but sometimes the shoe is on the other foot where, the local person, but again, it's rare, but when you do this enough, and we've been doing this for years and have done this a lot, you'll run into these situations. No, but we're human beings are involved. Nobody's perfect, and you'll occasionally run into these families, and it's our job to try to, suss out ahead of time what some of the issues are and give that advice. I mean, when people come and say, okay, what are the factors I should think about when picking an agent? Well, I kind of go through, I have a mental list in my head. All right, these are the things you think about, because you can appoint anybody. There's no rule you have to appoint spouse, children, whoever, or maybe you don't have a spouse or children. Maybe you have siblings, your cousins or best friends or whoever. It's really the number one top of the list, no questions asked, is the person is trustworthy, because the agent under a power of attorney has broad and significant powers over your assets. I mean, and that's necessary for them to do whatever's in your best interest, but that's a lot of power. So you have to have someone that's trustworthy, that realizes that it's not their assets, it's your assets, and they're managing it on your behalf, and they're going to really be careful with it and manage it properly for your needs. So being trustworthy, I mean, I often tell people the story where, I mean, obviously we didn't prepare the power of attorney, but we heard after the fact where, this woman, she was living in New York City. She didn't really have family or close friends, and she wanted to appoint an agent. She's like, all right, well, the doorman's friendly. I see him every day. He says hello to me. He takes my packages. He's nice. He takes, he helps me carry my groceries. And she's like, oh, okay, I'll name him as my agent. And he, went in and just cleaned out her bank accounts and fled the state. So, that's a rather extreme example, right? But it's an illustration of how powerful the document is, and then why it's so important to name someone that's trustworthy, that's going to, be careful with your assets. So that's number one on the list of how you think about it. Number two is someone that either knows your finances or they can get caught up to speed quickly. So, a spouse is typical. Most spouses, they're pretty familiar with each other's finances, but among your children or siblings, someone either who's already helping out or is capable of kind of getting caught up to speed, right? You don't have to tell them everything, but they could come over if it came, and they'd be able to get up to speed pretty quickly. And also someone with good financial sense. They don't need to be an attorney, even though it's called power of attorney. They don't need to be a financial advisor. They don't need to be a CPA or any kind of financial whiz, just someone with a good head on their shoulders when it comes to finances. Because, they'd be doing all the things you're doing, managing your bills and finances and investments. They'd be doing that. They still have their own finances, but then they're going to help you with yours. So someone that's got a good head on their shoulders, that their own personal finances aren't a disaster, hopefully, that would be able to step in and handle yours, and that has the time. So like I said, think of all the things you do to handle your own finances. Someone has to handle theirs, and then they're going to handle yours, that they have the time to do that. And the last, and kind of related to this, we were talking about swooping and what have you, it's helpful to have someone that lives close by, but it's not the most important factor, because of electronic banking and onlineness and bill pay and airplanes and cars and things like that. It's not as important to be close by when it comes to, being an agent under a power of attorney. You have, the other things, the most trustworthy person, even if they lived in, Oregon, is going to be more important than, a child who lives around the corner who, has filed for bankruptcy 3 times. So, the trustworthiness, the good with finances is more important. But if all things were equal, if you had someone local, that would be helpful. So those are kind of some things to think about when you're deciding who your agent should be. Any other factors that you think of, Melissa, or did I cover everything you would cover?
No, I think you covered everything. I think that just in addition to choosing the right person, I think it's really important to kind of talk about it and sit down and go over, what the assets are, where they are, where your income gets direct deposited, where you pay your bills from, are bills paid automatically? Do you write checks? Just things like that could take so much of the time and the burden off of the person that you're naming as the agent, just to have that bit of information to be able to kind of dive in if they need to help.
So who is this important for, and when should we get started? So would power of attorney really be the first thing that we would have in place? Let's say, we go into this webinar, we understand we want to get started, we reach out to Cona Law. Is this the first thing that we would get started with? And then how do we take it from there?
Well, power of attorney, healthcare proxy, and living will, which we're also going to talk about, those are the three documents that we typically prepare together. And who it's important for is really a great question, because most people think it's important for individuals who are getting up there in age, or maybe people who have, some sort of illness, or they're starting to lose some of their ability with memory and things like that. But really, these documents are important for anybody who is 18 or older, because once you turn 18, there's nobody with the legal authority to make any decisions for you, whether they're financial or medical. And we do have something in New York called the Family Healthcare Decisions Act, and we'll talk about that in a minute when we get to the Healthcare Proxy. But it's really important, and we strive all the time to educate the public on how important it is for younger people to have these documents in place, especially after the past 2.5 years with COVID. We all see that, bad things can happen to people who are young, as well as people who are older, who might be sick already, and there's accidents and there's illnesses and there are things that happen. So, we always use the example of, you have a child who's in college who just turned 18 on the other side of the country, who, unfortunately something happens and they're rushed to the hospital without, they're unconscious. They're not able to say, yes, you could talk to my mother and father. So they don't, and they can't talk to the mother and father. So getting that information about your, child, I certainly would consider that when my children turn 18, they're still going to be children, right? And that's what people say to us. They're like, wait, they're in college. I'm paying for college. I'm paying for, everything. How am I not able to get information about their, their health situation? 18 years old, you can't get it. So it's such an important piece of the puzzle that kind of gets overlooked all the time. So that was a long answer to your short question, but it's really important to everybody to have. It's a good
graduation gift. When you think about it, it's like turn 18, get that stuff in place, because nobody wants to think about that. But the reality is, if you don't, you can be in a really tricky situation.
Right.
Right. And you're even often using these documents when, you would least expect it, even if someone's not sick. Think about, Melissa, you remember those 3 months of lockdown and even further, where you have older clients who they're not sick. They're just older, concerned about going outside. They, their bank accounts aren't online banking, and they needed to take money out or transfer money around, and they would normally just go to the bank. But the family was terrified of their older parents, going outside. So if they had a power of attorney, the agent is typically empowered right away. We don't typically structure them where, you have to demonstrate that the person is incapacitated to be able to act for them for situations like this. What if, you needed your son, your daughter, whoever to, go to the bank for you and do something because you couldn't leave the house because there's a raging pandemic. So, there's a lot of unexpected situations that could arise where it would be important to have this document in place, because, if you don't have it and the person is incapacitated, they can't sign it. right? And, we've had situations where we said, unfortunately, they're not able to, we have a conversation with them and it's pretty clear that, they're just too sick, and get incapacitated mentally speaking. They don't remember where they are, memory issues, and, just it can become pretty clear that they can't sign anything new, because you have to understand what you're signing, right? You don't need to be, the perfect cognition, like, when you're, 22 or something like that. But, you have to generally understand what it is you're signing, because it's a very powerful document. So that's why it's important. Called Advance Directives, because you want to have it in place, because unexpected things can happen later, no matter what your age.
Absolutely. So tell us a little bit about the other important documents, the Healthcare Proxy and the Living Will. We're convinced we're all getting the power of attorney, right, everyone?
Right. Right. All right. So a healthcare proxy is similar in concept, in the sense that you're naming someone to make decisions for you, but it's for healthcare decisions instead of financial decisions. They're separate documents. Oftentimes you have similar or the same agents, but they are separate documents. So a healthcare proxy, legally speaking, it's a document where you name someone, pardon me, to make medical decisions for you if you're unable to make them for yourself. This one is always contingent on you being incapacitated. Your physician can determine, the person is no longer able to make their own medical decisions or communicate those wishes. Then, okay, here's their proxy. I need to call the agent to have these medical decisions made. And they can make all sorts of medical decisions for you, anything from, long-term, if someone has a longer term illness and they're making, frequent decisions on medication and treatments and this, that, and anything to really the end of life decision making, whether to continue life-sustaining treatment, or remove it. So a healthcare proxy, again, it's someone that makes medical decisions rather than financial decisions. Now, there's a couple of important things. One of the things that you want to make sure you have in the healthcare proxy is a Hipaa release. So Hipaa is a federal privacy statute where you want to make sure that your agent has the ability to access all of your medical records to make whatever decisions are necessary. And so you want to make sure that, that's in there. And that's also important for something that Melissa mentioned about, college age students or anybody who's young, appointing, their parent or parents as agents. Having the right release language means they can call up doctors and get information. Say, if they're across the country and they call up the doctor, in California, whatever, to get, medical records or what have you, so that they could check up on things. So those are important parts of a healthcare proxy. Another major difference is that you can only have one person at a time as your agent. This is different than the power of attorney, where you can have multiple agents, right? Where you can have co-agents acting at the same time. A healthcare proxy by the statute has to be one person at a time. And if you think about it, it makes a lot of sense. If you had two agents together and they disagreed and you had a deadlock, that's not a good way to make medical decisions, right? There would be no decision made, right, if they deadlocked. And sometimes the decision needs to be made right away, right? There's a medical emergency, you need to make a decision. Do we do this or not do that? You need to tell me in the next 5 minutes. You can't have a committee, right? Or it really wouldn't be in your best interest. So the statute says if you're going to do a healthcare proxy, it needs to be one person at a time, but you can have, multiple agents in succession. You say, okay, I appoint my spouse, then my daughter, then my son, then my nephew, then my whatever. There's no limit to the number of people, as long as it's, one at a time. And it's also really important to, have the conversation. This is another important, have the conversation with your family when making these kind of decisions, because, unlike financial decisions, which people have more time to consider them sometimes, you often have to make that decision right away. And that can lead to, conflicts within the family about care. And I know, Melissa, you've dealt with this before as well, with families having disagreements about care. One, because they didn't have a healthcare proxy, so you have a whole, Family Healthcare Decisions Act, committee. And two, even if they do, having disputes among family members and trying to resolve those, right?
Absolutely. I mean, that's, it happens quite often where family members might not agree on the decisions. And I often, when I speak to clients, really stress that in New York, your healthcare agent can be making end of life decisions for you. So you really have to think about that when you're choosing who you're going to have there in the first position. Now, we mentioned a couple of times the Family Healthcare Decisions Act, and that is something that was put into place so that if there's no healthcare proxy, the doctors or the hospital, they have kind of a list of people that they can go to to make decisions. So starting with a guardian, a spouse, children. The problem is, while it's great that it's there, it may not be the person that you want making the decisions who comes up, next in line, if you will. And, by doing the healthcare proxy document, you're making the choice of, who it is that you want making those decisions. I've had plenty of married couples who have not chosen their spouse as the first person to make the decision. They've chosen a child, and they'll say things like, I know that she'll do X, Y, and Z. I know that I don't think my husband will be able to, take me off life support, but I know that my daughter, has the ability to be able to do that and make that decision. So it's very tricky sometimes. And I'm sure Marcus has seen this as well, where, the family, the person signing the document wants to name this person because they're the oldest, or they don't want to insult them, or, something to that effect. And it's just such a big decision. You have to really think about who the right person is, as opposed to, not offending somebody, which I understand, but it's too big of a decision for that.
And is that
Right.
something you help people with when they're sitting down with you, each of you? Is that something that you help people, ask them the right questions and help them pick the right person for them?
Absolutely.
Right.
Go ahead, Marcus.
Yeah, so we both said absolutely. It's really, like Melissa said, relying, on the Family Healthcare Decisions Act is nice that it's there, but you can have a situation where, well, it's your children and you have multiple children and they're having a dispute, and it really, throws a wrench into the works, which is why every time that you're admitted to the hospital, most of them were, the first question they ask is, do you have a healthcare proxy? Who's your healthcare proxy? Do you have the document? Oh, you don't have one? Sign this one. Pick someone, because they want one person to take direction from. They don't want to have a whole family blow up in the lobby and what have you of the hospital. I guess they're letting people in these days most of the time. So, but
think of My Big Fat Greek Wedding. Like, think of that in the waiting room of the hospital.
yeah,
Right.
right, and you really don't
Chaos.
want to have that. You don't want to have that chaos. So when we're sitting down with people, we go through, again, just like with the power of attorney, there are different factors or things you should think about when you're deciding who your agent would be, and they're a little bit different because it's not a financial decision. So if the person is terrible with money, that's not necessarily a problem when it comes to making medical decisions. So you want to think about a person, number one, who's reachable. Okay, because sometimes you're going to need to make a decision right away. Now, reachable doesn't necessarily mean they live next door, but someone who will answer the phone when you call, or when the doctor is calling, or if they're knowing that there is going to be medical issues, that they make themselves available. If someone is they're travel internationally because of work or whatever, their own family situation, that can make things difficult, right? Especially if the parent is older and you're more likely to perhaps need to make those decisions sooner rather than later. So someone that's reachable, can get on the phone, was able to get back to the doctors quickly about decision making. That's really important. Being close by is very helpful, or can travel easily, because if anyone who's been involved in the medical system on hospital or nursing home care can tell you that having someone as your advocate is essential to getting good care, right? Because healthcare workers, they do their best, but they're really overwhelmed these days. They have a lot of people that they're caring for, and if you want the best of care, you have to really, advocate for and really stay on top of things. The doctor has 300 patients. You have to make sure they're getting over to see your mom, right? You're spending the time at the hospital, making sure that everything is the best care is given. So having someone that is either local or can be local when needed is going to be an important consideration. Again, not just the oldest child. You want to think about important things like that. Someone that can handle stressful situations, right? Making, medical decisions for a parent, especially end of life decisions, is extremely stressful, right? It's maybe the hardest decision you'll ever make in your life about whether to continue treatment or not for a parent. And so you want to make sure someone is able to make those decisions that can handle that. I mean, it's very difficult, and really not only can handle it, but is willing to make those decisions, right? If your wish was, if I got to this point, I wouldn't want continuing treatment, you want your agent is willing to make that decision and to let go, to withdraw treatment if it's what you would want. So, that's a really important factor. What Melissa was saying before, I don't think my husband can do it, I'm going to appoint my child. That happens on occasion. I mean, most people appoint their spouse as their primary agent, but it doesn't happen all the time. More common is the trying to figure out if you have multiple children among, who's going to be the agent in those circumstances. But, that's an important consideration. They're willing and able to make that decision. Also, someone that knows your wishes, that you've had a conversation with about what kind of treatments you would or would not want in certain circumstances. They know your wishes and they can act on them when the time comes, and really kind of can manage people. So managing doctors and manage those family situations, right? That's going to inform the family members, the other, whoever they may be, of what's going on, keep them in the loop, can manage, freakouts and, angry people and disagreements. There's not always going to be complete harmony, but someone that can handle, those disagreements, and just to make sure your wishes are being followed is really an important, factor to decide. So, when we're meeting with clients, we kind of go over those things. All right, here's your pool of people you've been thinking about. Here's how you decide among them if you have a decision to make, and don't just default to, your oldest. Or sometimes people have a nurse or a doctor in the family. It's, oh, my daughter's a doctor, I'm going to name her as my agent. Sometimes that works, sometimes that doesn't. So you really want to, consider, all these factors, when picking an agent.
I want to make sure that we also get to, because it's very important, the power of attorney, very important, the healthcare proxy. And it seems power of attorney is more financial focused, where the healthcare proxy is more healthcare focused. I do want to get to the living will. Can you touch upon what a living will is and why it's important?
Sure. So a living will is documents your wishes as far as end of life treatment. When it comes to, and it comes into play when you can no longer make that decision for yourself. You have an irreversible loss of the capacity to make those decisions, and you have kind of an end of life situation. So, an incurable, irreversible condition likely to cause, your death within a relatively short time. And the question becomes, do I want to continue treatment, or no? If I'm in that end of life situation, I wouldn't want heroic measures and continuing life-sustaining treatment and, ventilators and respirators and machines and things like that. And I would more focus on, comfort care, palliative care. Even if it shortened my life a bit, I really want to focus more on quality of life. So expressing that in writing is really important, because a lot of times the law will, if you never told anyone or never written it down, it's going to assume that, you would want to be kept alive as long as possible. And not everyone wants that. So the living will is your way of expressing those wishes in writing, and it basically informs your healthcare agent of your wishes. So they're typically separate documents. They work together, but they're really separate documents.
Fantastic. Melissa, can you share a little bit about that, and who, a living will is important to, and what stage of life would you think about that?
Again, I'm always going to go back to, the 18-year-old, because we never know what can happen. I don't want to be, the Debbie Downer, but you don't know what could happen to anybody at any time. So it's really important to have all of those documents in place once you turn 18, because you need to be able to document what your wishes are. And in addition to what Marcus was saying, if the healthcare agent is making a decision, an end of life decision, and a family member does not agree with that decision, having your wishes in writing, can really kind of save the family from having to go through a potential court proceeding to carry out what your wishes are. So it's even though it's not a statutory form or required, it is extremely important. And to add to that, if you are moving out of state or you spend a good amount of time in two different places, it's important to have documents in different places, because the rules are different, the documents are different, the decision making is different. For example, in New York, the Healthcare Proxy can make end of life decisions. The Healthcare Proxy is the controlling document, whereas I think it's Florida, right, Marcus, that the living will is the controlling document.
It's just, different states have different setups. And, while documents in one state are theoretically valid in other states, the most states have book statutes and say, well, if you have a power of attorney or healthcare proxy valid in another state and you signed it there, it works here. Practically speaking, if you're in Arizona or something on vacation, or you have a summer home there, or in Florida, and you try to bring a New York power of attorney into a bank, it can cause difficulties. Not that they might eventually accept it, but it goes to the legal department and it sits around for a while. And so it's important, if you spend a lot of time in multiple states, just for your own, sanity and ease of use and administration, it's typically a good idea to have a set of advance directives for both states. And that's really for, the snowbird types and things like that who are in more than one state on a regular basis. If you're just going for a vacation, no. But if you've got a home in Florida and you're there 4 months of the year, it's typically a good idea to have a New York set and a Florida set.
That's really good advice. It's not even something that I would necessarily think about.
Right.
So do these documents expire? Is this, do I come in and do these documents and then have to come in annually or every 5 years? How does that work?
Well, they don't expire per se, but they do change. And sometimes the regulations and statute changes. We just had some major changes to the power of attorney, but typically it will say that if you signed your document prior to the change, and then your document is still good. But what we see happening over the years is, as we get further and further away from each kind of draft of the document, the banks don't recognize it, or they make the argument that it's not valid anymore because they've never seen it before, or they know it's old. So we do constantly update our clients when there are changes, when they should consider updating their documents. Marcus, maybe you want to talk a little bit about what changed?
Sure. So, the power of attorney changes every once in a while. A healthcare proxy, not so much, but the power of attorney form changes, and changed in 96, and it changed in 2009 and 2010. And now most recently, last year in 2021, they made some changes to the form, meaning the state legislature made some changes. To the layman, it doesn't look all that different, but the guts of it have moved around a bit. There used to be a separate statutory gifts rider. Now that's moved into the modification section. The base power of attorney used to just require a notary. Now it also requires 2 witnesses. They loosened some of the requirements. So if you made a typo here and there on the form, it's not going to render the whole thing invalid, which sometimes was the case under the previous one. It was kind of harsh. And they had some additional penalties for banks and other financial institutions that are refusing to accept valid powers of attorney. They put some procedures in place that they have to follow, and some penalties for them not doing it, to try to discourage the automatic rejecting. Some banks were insisting, oh, you have to use our form, just, because they didn't want to deal with it. So they're not supposed to do that. And so, like Melissa said, the prior ones are grandfathered in. So if you sign one in January of 2021, you don't need to change it just because the form changed. But the further back you go, the more iterations. Like if it's before 2009, the form changed drastically in 2009. We're recommending people update it just to make it easier to use, right? So you're not going to run into a situation where it's sitting in the legal department for 3 weeks of the bank or brokerage firm. In addition, just like with any other kind of estate planning, you want to take a look every few years to make sure it's current, right? There's life changes that maybe you want to change who your agents are. If you have, family dynamics change, the relations among your children, like Melissa was mentioning earlier, as parents get older, maybe they want to have their children as co-agents. Maybe as you get older and you have documents from your 30s, and now you're in your 50s or 60s, and your children are older, and maybe you want to have them as co-agents instead of your sister or brother or whoever, because they're older. So over time, things change. I mean, Melissa, I usually tell people, just take a look at them every 5 years or so to make sure everything's current, right?
Absolutely. Absolutely. And I've had people, change, oh, my son got married and now he's not going to be making the decision, the wife is, or vice versa. So I can't have him on there. And, it's again, I'll go right back to what I said in the beginning is just, understanding the family dynamic and asking about it, right. And getting that information so that people are aware that they have the ability to make these changes and that they should if they're not comfortable.
So what happens if someone doesn't have any of these in place?
So that does happen, where we'll have a family call us to do, let's just say, a Medicaid application, situation like that. And we'll ask them to send over the power of attorney and the healthcare proxy. And either they don't have them at all, or they're completely, improper documents, maybe downloaded off the internet and they used a different state's documents. We've seen things like that. So in those situations where the person can no longer sign because they've declined mentally, they're incapacitated, and they can't execute these documents anymore, the family really has only one choice, which is to bring a guardianship proceeding. And a guardianship proceeding will eventually get you to the point where somebody is appointed to make medical and financial decisions for you. But the time and the cost and everything that goes into it, especially if family members don't get along, can really be overly burdensome. So it would mean, say, a child filing a petition with the court that, mom needs Medicaid. We can't, she can't do any of these things on her own. She doesn't have a power of attorney. She doesn't have a healthcare proxy. So I'm petitioning for the court to appoint me as her healthcare proxy and her power of attorney. Maybe the family's all on the same page and things move smoothly, but you're still going through the process and it takes time and it's expensive. In other circumstances, the child files that petition and then another child comes back with a cross petition and their own attorney because they don't think that this person is the right person to be the guardian. They should be the guardian. And I mean, it can turn into a circus, and we've seen it happen. And you can really avoid all of that, that chaos, like the word of the day, chaos. And by having the documents in place, and you can also bring guardianship proceedings if you have the documents in place and perhaps one family member feels like the person acting as the agent is not doing things appropriately, like the doorman in Marcus's story earlier. There's repercussions too for not utilizing the documents properly, and that's going through the guardianship court.
Wow. It's really important, the kind of the gist of National Healthcare Decisions Day and talking about advanced directives is really the importance of you being able to pick your decision maker for yourself, not leaving it up to default statutes, who a judge is going to pick in a guardianship proceeding. It's not just the expense of the guardianship proceeding, it's you not controlling who's going to make those decisions for you. Maybe the judge picks someone else, or maybe says, pox on all your houses, I'm going to appoint someone off a list who knows nobody. An independent guardian who's not a family member, and maybe sometimes they care, sometimes they don't. The core of the goal here is to have a document in place that reflects your wishes,
right,
who your decision makers are, and alternates. Have it updated and current, so that if the time comes, the decision maker will be in place that you want, and you're not relying on default things, guardianship, etc., which takes it kind of out of your hands. So that's the overriding theme, and why it's important to have these things. And you don't want to just say, oh, my kids will figure it out if I don't have these documents. That doesn't usually end well.
That's a really great. This has been so helpful. I want to get to a couple of questions that we do have from the attendees. We could sit and talk about this for hours because it's such valuable information. I did share with everyone in the chat how to get in touch with Cona Elder Law, and even Melissa's email directly. So if you have questions and you want to ask questions, get things started, please reach out to them. Obviously, this is very critical. Marcus, I think you round that out for us so powerfully. But a couple of questions. One question is, should you also have a living revocable trust? Sandy wants to know, and can you explain what that is? I'm sure it's intricate, but can you just give us kind of a quick overview of what that is, and is it critical to have?
Sure. So a trust is a different estate planning. It has to do with asset protection, inheritance arrangements, and avoiding probate and things like that. A trust is say, okay, when I pass away, the assets in this trust are going to go to these people. It's a way of estate planning. And revocable trusts are, and I'm going to do this very quickly, revocable trusts are people put in place to keep control of their assets, but after they pass away, skip over the probate process and have it go more quickly to their children or heirs or beneficiaries. Typically, our clients, we're suggesting more irrevocable trusts, which are used for, not only do they typically avoid probate, but they're used to protect assets in the case that, a senior or an older person needs long-term care, at-home nursing care, a nursing home, things like that. You want to protect your home and other assets. So typically we're doing irrevocable trusts, but any kind of trust is typically more of an inheritance arrangement or asset protection arrangement. Sometimes they get used for like helping manage during incapacity, but that's kind of a side benefit, but typically used for inheritance and asset protection purposes.
Sandy, reach out to Cona Law.
Right. That's right.
That's like another 3 webinars.
That's right.
I don't want to open. So Marguerite wanted to know, the children as co-agents, can hospital require only one with one alternate substitute? And what assistance should family request mediating decision making? So I guess the question is threefold. Can there be co-agents? Can a hospital require one at a time? And what we would do about mediation if necessary?
Well, the healthcare proxy is only one at a time, and it's not necessarily the doctor requirement, it's the statute. You can only have one person named as a healthcare agent at a time. So like Marcus said earlier, if you have 2 children, you can have them both on there, but it's one at a time. So you have to choose who's going to be first, who's going to be second. The doctors only want to hear from one person. It doesn't mean that the family can't make decisions together. Doesn't mean that the children can't, convene and discuss. And in some cases, if there needs to be mediation to discuss the decision making, that's something you could absolutely do. There are individuals also in the hospitals that would facilitate that if there needs to be some discussion, but you can't have co-agents on a healthcare proxy.
Thank you for that. Now, Jody wanted to know, I have no siblings, no children, no spouse, and my friends are my age. I'm challenged in picking a power of attorney. What is your suggestion?
Well, it can be a challenge. There are, you can appoint family friends, You could appoint trusted advisors. There are some companies out there that we work with that will serve, that they're independent and they will serve as agent for people. And they help with financial management and money management and things like that. So for clients who really don't have anybody, because you don't want to just pick someone just for the sake of picking someone, because again, it's a very powerful position. But it requires a little bit more thought in planning, as to what a power of attorney should be. That's the type of person that'll often have a revocable trust. Maybe they'll get a bank involved or other financial professional to step in and be their agent and or trustee if the time came and if they became incapacitated. So there are options. It's typically professionals and financial institutions that, but only certain ones are interested in doing that could step in those situations if you don't have an individual.
Thank you. Eileen wanted to know, speaking of having people help you, are there professional bill paying services to hire if you don't want to burden your family or friends to do that portion?
Absolutely. And we deal with that quite a bit because now families are really scattered around. And like Marcus said earlier, even though it's not required that your agent be nearby, sometimes it becomes very tedious and difficult if they're not. And so there are certainly there are individuals, there are companies that will act as money managers, handling the bill paying and doing all of that work. Kind of like a boots on the ground, with the kids or, the family is nowhere near the individual.
Great, thank you for that. Jane wanted to know, what is the Healthcare Decisions Act? I live in New York State.
So the Healthcare Decisions Act is a statute that says, okay, in New York, if you don't have a healthcare proxy document, here are the kind of default people that the hospital, the doctors look to make decisions for you. There's a priority, like Melissa said before, guardian, spouse, children. So there's an order of people. So it's helpful in a pinch. The downside is, again, you not being able to pick among those people, especially if you have multiple children and it kind of you're gonna have a committee there. You want to have the healthcare proxy in place so that you can pick. But if you had nobody at all, or if you didn't have one, there is at least that fallback.
Terrific, thank you. And just to round it out, how we have an attendee who asked, how do I start the process and to do all of these things? What is the next step I should take?
Well, anyone who wants to get these documents into place, they can reach out to our office. We would send a questionnaire out because we like people to kind of get all of their information into one place, and it's helpful because it triggers the thought process of what you're going to do. And then we provide consultation and go over all of the documents, plus maybe some other things depending on their situation. And then we'll take it from there. We'll draft the documents, send drafts to them to review, and then have them come back in to sign everything once it's finalized.
Fantastic. So what I did is I just shared the number and website. Melissa, your email in the chat again. I'm also going to share that. Everyone will get an email tomorrow. I'll share that information there as well so that people can reach out and deal with their personal, because everything is so individualized. They can speak with you about that. This has been recorded, and we will have the editing up on the edited recording up on the Schneps Media YouTube channel. We'll also send you the link, so you will be able to watch it again, to be able to get this great information again, but also to share it with your family and your friends. Please do. This is such critical information that everyone should have and should start working on at age 18, as Melissa was saying. Absolutely. And it really, certainly, you've shared what a gift it is, not just to yourself, but your whole family, to be able to make sure that these things are in place. I want to thank Marcus and Melissa. Thank you so much for this critical information and spending this time with us this morning. We truly appreciate it. And I also want to thank all of our attendees for joining us this morning to get this critical information. So I want to wish you all to stay safe, stay healthy, and I'll look forward to seeing you on a future webinar. Thanks so much.
Thanks, Elizabeth.
Thank you.
Take care.